So just to recap, the disciplinary procedure that was invoked the first time, that was in terms of Regulation 9.
No.
Or Regulation 8.
Regulation 8.
Regulation 8. That was the one where you appeared before Advocate Matau SC. You say there were initially 11 charges, which were then reduced to 3. But in any event, you were never asked to plead to those charges. So those, even though you appeared there on a few occasions, that hearing, in fact, never got off the ground. It never commenced.
No.
Subsequently, the disciplinary action was then changed to Regulation 9, what is called an expeditious hearing in relation to senior management officers of the police.
No. May I allow, Chair, sorry, am I allowed
you
to
must
correct
please
you?
comment. If
Yes.
I don't have it right or I have it wrong, then you must please correct me. You then, that resulted in your appearance before Brigadier Riet.
Lieutenant General Riet.
Lieutenant General Riet.
Yeah.
Yes. That is called an expeditious, what's it, expeditious hearing?
Expeditious process, Regulation 9, yeah.
And that's before him as a single officer, disciplinary officer. Those proceedings are also set out. Can I refer you to the exhibit bundle, item 1, and item 2 is a record of that process. That is the formal notice of this expeditious process. Is that right?
Which one?
The exhibit bundle.
Yes.
Not the big one.
Yeah, I'm on it.
That one, yeah.
Your own exhibit,
Yes,
not mine. Okay.
Yes, our one.
Yes.
Yeah.
It's
right at the beginning. Item 1 is a notice of outcome of the expeditious process on the 24th of. Yes, the first item. That's a notice of the hearing, and the outcome is at Annexure G, if you page a few pages down, and yeah.
sorry, Chair, I'm losing you. What is few pages down?
The first item is called a notice.
No, I can see 1 and 2, the record of proceedings.
Yes.
And then?
Yeah. So it's really just to reference the process that I was referring to, and you were busy trying to correct me.
Yeah.
So it's just a matter of process.
Okay.
Yeah. So that process took place not in front of Matau, but in front of Lieutenant General Riet. And that was a process that was different to the initial disciplinary process for which you were asked to appear.
Okay. Am I?
Yeah.
So, if I'm allowed, in responding but also correcting you, the expeditious process is not meant for senior managers. The expeditious process is a provision within the South African Police Service Discipline Regulations 2016. And I happen to be the accounting officer together with my former minister, Minister Nhlanhla, that signed those regulations into operation. And that expeditious process is currently being abused while people are spectators. The expeditious process is supposed to be used where, for example, there is direct evidence, something that you cannot contest. For example, we were sitting with an issue of members, somebody who is being arrested in the middle of a cash heist. This member was maybe either the driver of a getaway or he was part of the group. In that particular instance, all what is required is a factual report. When the expeditious process was put in place, it was in inverted commas to make provision for a summary dismissal, because there can never be any justification of a member of the South African Police Service involved in crime, whether it is rape or what. But in cases where there is evidence, there is witnesses, where people must be called to either corroborate or deal with the issues, the expeditious process is a wrong process to follow. It is for that reason that I'm saying expeditious process was not meant for senior people. It is meant for all. Now, coming back to me, even the Terry Motau process, let me tell it that way, the one where he was appointed to chair, it was unlawful in my case because the discipline regulations do not apply to the national commissioner or the acting national commissioner. The acting national commissioner or the national commissioner is to be subjected to a process provided for in the Police Act and the Constitution in terms of holding a fitness board. So both processes were not to apply to me. I just said in the beginning, I was removed from office by the minister who was by law not allowed to do so. Now, the question is, when I left the 1st of June, where did I go? I never went to any police office. I've never seen a police office till today. I went to my house. So, if they wanted, they could have allowed me to go to my position as the Divisional Commissioner of Forensic Services and then take action in line with the discipline regulations, because they would have fully and squarely applied on me. Now, I'm to some extent disappointed because I've got a half-baked document here which you say it's evidence. If you look at this document, you will see the first document. The first document is read as document. Then you have here what comes from Nhlanhla, which allegedly, according to the discipline regulations, is supposed to be an investigation report. No.
General Phahlane, we also do our own research and we make efforts to find relevant documents. These documents have been presented to you and are placed before the committee, not to argue with you. It's to place certain issues on the record. You've made your position clear. It's not apparent, though, from the proceedings before Lieutenant General Riet that you raised that as an objection. But be that as it may, can I move to the next item?
No, but Chair, I can't. You can't attribute something to me and move on. That has been ventilated.
Okay. So if you raised it before Van Riet, the proceedings are there before you. Can you point out where you specifically take issue with him and say you are not competent or you don't have jurisdiction to conduct this investigation or this hearing?
It's Chair.
Because I was going to try and speed up matters, because subsequently you did approach the Labour Court, and that judgment is also in the bundle. Unfortunately, Honourable Chair, Honourable Members, we didn't have time to index, or there is an index, but we didn't have time to paginate the bundle. So if I may just ask for some indulgence as we page through this, but there's a judgment of Judge Van Niekerk, one of the senior judges in the Labour Court. General Phahlane, did you manage to get there? It's item 3. Item 3 is the judgment of Judge Van Niekerk.
Chair, if I am to go through this and respond to it in detail, I would have provided you with more information to this. So now we are confusing issues. Judge Van Niekerk's process came after the initiation of the charges. It is me who took the matter to court, and we were arguing a different issue there. We were not arguing the charges.
Yes, you had by now been dismissed.
No, there is no such.
Can we? I don't have time to argue with you. Can I just read from what the judge?
Let me just
Can we just read what the judge says?
Which page is it?
It's the third item. It's the Labour Court judgment of Judge Van Niekerk. It's in the exhibit bundle. Have you got it now, General?
I have it.
Yeah. So you'll see from page 2 of the judgment, this is what the judge says. This is an application in which the applicant, that you, seeks in terms of his amended notice of motion to interdict the second respondent, that's the National Commissioner then, from confirming or ratifying a decision taken by the third respondent, that's Lieutenant General Reed, to dismiss him and to declare unlawful and set aside disciplinary proceedings initiated against the applicant in terms of Regulation 9 of the SAP's disciplinary regulations. In the alternative, the applicant seeks an interim order pending the institution and finalization of an application to review. So this is where the judge summarizes your complaint, and which is what you indicated earlier. The applicant's complaint is that the first respondent, the SAPS, is using Regulation 9 to circumvent a disciplinary process already underway in terms of Regulation 8 before an independent chairperson, Advocate T. Matau SC. Then the judge goes on to say the regulations are in the Gazette. They're based on a collective agreement between SAPS and the trade unions. And then he records that Regulation 9 provides for an expeditious process. And as the title implies, it provides for certain cases of alleged misconduct to be determined by way of an expedited hearing. And then in paragraph 3, it deals with some background of how you appeared before Advocate Matau, and your allegation that the SAPS was now acting mala fide, because you can't defend yourself in an unbiased forum, as you put it. So after the argument, the judge dismisses your application and doesn't make a cost order. And at paragraph 10 on page 6 of the judgment, the judge says, in short, the pleadings do not disclose a cause of action over which this court has jurisdiction. So the point is, you were asked to stand down. I'm just summarizing. You were asked to step aside or stand down by then Minister Mbalula. You were issued with a notice of suspension. You were then issued with a notice of a disciplinary inquiry, initially before an independent third party, subsequently in terms of this expeditious process. There was an outcome. You sought to interdict the outcome of that process, and then that application was dismissed, and subsequently your dismissal was confirmed. And you contested all of that, but is that a fair summary of the facts?
Chair, while this is not the process where I want to ventilate this, I suspect your reading of the process is wrong, and it will be misleading. We have never challenged the merits of the matter before Van Niekerk. When we went before Van Niekerk, the intention, it was between the sanction and the confirmation. What we were challenging there was because if you look at the record somewhere, if you had obtained the comprehensive records, you would have seen that after Reid arrived at his sanction, which came as a shock, in a finding, not a sanction, we initiated this process because the regulations provide for mitigation and aggravating circumstances. You will not find any mitigating circumstances coming from me because we were challenging that particular process. While we were still waiting for a court day, as usual, they moved on and came up with a sanction. Following that, we accepted that I'm not going to contest this because the correct platform is to go to the bargaining council, which we did. So the Haramse judgment has got nothing to do with the merits. Van Niekerk judgment has got nothing to do with the merits of the matter.
But General Phahlane, be fair to me. So I just read to you a few minutes ago on page 6, paragraph 10. This is what the application was about. He says, the pleadings do not disclose a cause of action over which this court has jurisdiction. It was a technical issue. I accept what you're saying, that it didn't deal with the merits of your matter. I accept that.
You said it's page?
It's on page 6, paragraph 10.
Oh, sorry, I'm looking at the wrong document.
And he expands on it in paragraph 12, where he says, in the second sentence on page 7, the applicant appears to indicate that he intends to invoke this court's review jurisdiction in terms of section 158(1)H, that's of the Labour Relations Act, which entitles an applicant to review any decision taken or act performed by the state in its capacity as employer on any grounds permissible in law. So that's his discussion. And then he goes on to say that he doubts whether you have established a prima facie right for the purposes of any interim relief. So it's a very technical judgment. You were the applicant, presumably on legal advice. And from the appearances, you were represented by senior counsel and a junior. And it was to interdict the outcome of the writ process, isn't it? And that interdict was refused. So the writ process, and that's what I want to move on to. I'm not debating with you the merits of your case or the merits of the charges on which he found you guilty. because we can't resolve it in this forum.
And I don't want it to be resolved here because I'm not looking for political interference. And I'm not going to get stuck in dealing with the judgment, which I'm trying to explain to you. You only go and read what you want to carry across. And I'm trying to explain to you the context. And we have moved on from this judgment. We have accepted that this judgment did not favor us in as far as interdicting the process is concerned. And this judgment had nothing to do with the merits. In reviewing, we went to the correct platform, which is the bargaining council. And it is there where the merits were ventilated. And we talked to it in here, where still the outcome was not in my favor. I then went on to the labor court. Again, it was not in my favor. I am on the doorstep of the Labor Appeals Court. We are awaiting judgment on that one. So I don't want to spend time talking about the Van Niekerk judgment, which was I never challenged it anyway, because I accepted that there is a need to move to the right platform, which is the bargaining council, where the merits and the process were to be dealt with. There are no merits in this particular case.
General Phahlane, at the outset, everybody, all the honourable members, all of us accepted that we will not speed through your affidavit because you're entitled to fully vent whatever views you have. You, in your affidavit, a considerable affidavit, you spend 9 pages on challenging what you regard as the unlawfulness of your dismissal. So, and we had these engagements over the December holidays with you and your council. We discussed the issue of relevance to the terms of reference of this committee. So now you tell me, no, you can't go there and read from what Judge Van Niekerk had to say in this application. That is what I'm doing. If you want to speed through it, then I'm quite happy to agree with you. One, that the Van Niekerk judgment didn't deal with the merits. The first time the merits of the charges against you are dealt with is in this arbitration award, which is the next item, which I want to come to. In that arbitration, the arbitrator upheld your dismissal. You weren't happy with that. You took that on review. It went to the Labour Court. The Labour Court dismissed your application for a review. You asked for leave to appeal. Your leave to appeal was refused. You then petitioned the Labour Appeal Court. That petition was upheld, and your matter was heard by the Labour Appeal Court. I think it was on the 16th of December last year. And that outcome is still pending.
It's not correct. 16th of September, 2025.
So is that a fair summary of where we are?
No, 16th of September.
16th of, what did I say?
December. I was busy with an affidavit on the 16th of December.
September, sorry. 16th of September.
Chair, all I'm saying, and I must be understood, there is nothing wrong to make reference to that, and it is in here. But I've got the problem if you are making reference to that out of context, creating the impression that Van Niekerk dismissed my application, not, and somewhere you mentioned the correct, on technicality, not on merits. And I did not have time to contest Van Niekerk's judgment because it was just not going to take me anywhere. The correct platform was the bargaining council where I went to. And I ventilated the issues there. Whether I agree with the outcome or not, it's a different matter. The matter was ventilated at the bargaining council. Outcome came not in my favor, and I'm saying so in my affidavit, that once that came, follow the process, go to the labor court. Outcome came not in my favor. The same acting judge refused us leave to appeal. It is for that reason that we went to the labor, we petitioned the Labor Appeals Court. And the Labor Appeals Court hearing took place on the 16th of September. When I started, I said, the outcome is imminent. So I really don't have time, energy to waste on the issues that are correctly at the labor court. I was here correctly giving an update of where they are, because somewhere you hear somebody, he was fired for the blue lights. I want to know, where is that blue lights? He was suspended for the blue lights. Show it to me.
So shall we move on from there, or do you have anything else to say about your dismissal? Can we accept that the issue of your dismissal, both procedurally and substantively, in other words, on the merits, has been before an independent, a bargaining council arbitrator? It's gone to the Labour Court, and it's gone to the Labour Appeal Court, and until such time as the Labour Appeal Court might rule differently, you have been dismissed by the SAPS in what the arbitrator and the courts thus far have agreed is a procedurally and substantively fair manner.
If that is placing you, let it be. And that's exactly why I'm putting it here. It's nothing to hide about. I don't find a reason why I should be arguing. If you were to go into the very same issue, I don't know why we jump so quick to it.
Because we are going to come to an important issue. Sorry, I see your counsel wanted to. Sorry, Chair.
Sorry, Chair. I was listening to some learned people here behind me. Yeah, I'm all yours.
Yeah. All right. So the relevance though of so we put that behind us now, the issue of your dismissal. The Honourable Committee is aware of the fact that you're unhappy about your dismissal. You've challenged it, but as things stand, as we sit here today, your dismissal, both procedurally and substantively, has been upheld by the courts. And yes, you've challenged it, but to the extent that you now argue or contend in your affidavit that you've been what you call unlawfully dismissed, that has been dismissed by the courts. Can you at least accept that?
What must I accept?
That your complaints and your case against your dismissal has been dismissed in arbitration and by the courts up to now.
The question, and I know I'm here to answer questions, the question is, why do you put that to me while it is part of my affidavit? And that's exactly what I'm saying. I have outlined a process which allows you and the honorable members to have background to that. And I emphasize, I am not here for that. This is a matter ventilated elsewhere. This is a matter that belongs elsewhere. This was by way of background. Where am I? What is happening? Somewhere you started by asking me, where are you working? And I'm saying, I'm working in my garden. I'm at home. Now I'm giving you background. Why am I in my garden? Because I was unlawfully dealt with, and the matter is at the Labour Appeals Court. Let's make peace with that. That's where it is, and go into the issues that need to be dealt with. Part of what I'm saying there, I'm also showing you, giving you even why why I'm even going to an extent of talking the unlawfulness and people in authority who disobeys the laws. I'm giving even annexures. I gave you documents to that effect. But for the sake of progress, I've never came here to say I'm still employed. No, I'm in the Labour Appeals Court. We're waiting for a judgment. So we can move on.
Thank you. Now, one of the big issues that came up in the expeditious hearing and subsequently in the arbitration was the tender relating to the 360 by 180 degree cameras.
Where in my affidavit are you, Councillor?
Don't you deal with the Itemba tender? You deal with it in your affidavit.
Yeah,
it's very much at the heart
really
of your complaint.
Yeah, for me not to be lost, because now one moment we are moving away from the dismissal and so on. Now you go back, because that's part of the reason why this matter is before the Labour Appeals Court. I thought that we have agreed. If we have to deal with the tender,
Phahlane, let's do like this. The statement that the witness has deposited with us is numbered in paragraphs, isn't it?
Really? Page 18.
I think that is the approach that we must take. If we are on page 18, let's go to that page in the specific paragraph.
It's item capital letter E on page 18. General Phahlane deals with the procurement contract bid 19/1/9/1/187, that the supply and delivery of the 360 by 180 panoramic image capturing system.
Did you get that page, General?
I'm there, Honorable Chair.
Thank you. Let's proceed.
And General Phahlane, you and I had agreed that these court process, arbitration processes, that's now where they are, and it's subject to the Labour Appeal Court now also sitting and considering your application to appeal. But in relation to the merits of the case, that's where I'm moving towards now. The merits of the case, the matter is dealt with fully, not perhaps to your satisfaction, but dealt with fully in the arbitration award, which deals with, amongst other, this particular tender. Do you want me to take you to the relevant passages, or do you accept that this Itemba FDA issue was dealt with in the arbitration award?
No, Honorable Chair, I'm not going to accept that approach. I'm not going to accept to be taken through an arbitration document while I'm contextualizing that issue. Here in my affidavit, it's 8E, paragraph E, and we are from 44 going forward. So we can deal with what I am saying in relation to that. If you want to go and refer to some aspects of the arbitration, because we are saying it here, I'm not going to repeat the arbitration, which we have extensive legal documents before the courts on it, and I'm saying I'm waiting for the outcome thereof. So, to be fair, Chair, I must be spoken to on my affidavit. The issue that the council is trying to talk to is traversed from page 44 of my affidavit, and it goes on. Sorry, paragraph E, paragraph 44. I talk to it not selectively.
Can we understand this? Advocate Adams and General Phahlane. General Phahlane,
Chair.
you say that the matters on which you are being questioned are still before the court.
Yeah.
So you are essentially saying to us that the what do you call it, the award of the arbitration award has been appealed.
Yes.
And that the judgment of the Labour Court as well,
Yes,
has been appealed. And now we are awaiting the judgment of the Labour Appeals Court.
yes,
And you argue that it may be unfair to ask you questions on matters that are still lispendents. That we must wait for the judgment of the appeals court.
no, am I allowed, Chair? No, that's not what I'm saying. Because I have spoken to the issue myself in the affidavit. It is here, paragraph E, from page 44 until page 81. What I've got an issue with is that now I must go through the arbitration award, which I did not even bring here. It is council and them who went to go and fetch it from wherever they fetched it. So because it's something that I've dealt with extensively, challenging that arbitration award, challenging the Labour Court review award or judgment, and the same matter is now where it's pending before the Labour Appeals Court. So all what I'm saying is that don't go and take the pieces of the applications that we are lying there. I have spoken in detail. Now the council was talking about the procurement contract of the the 360. Here it is. So why must I go and look at a document which the reason why I'm challenging it is because I don't agree with what the arbitrator wrote there. Now I must now go and argue with council on something as if I'm before the very same arbitrator. I'm saying, let's talk to it. But here is my affidavit. It's talking to the issue.
You say that those matters are on appeal.
Yes.
Yes, that is the point that we wanted to get, that
Yeah.
those matters are on appeal. So we may ask you questions from a wrong premise or from wrong assumptions, because we don't know what the decision of the appeals court may be.
Mm.
If the appeals court comes and upholds your application,
Yeah.
we might have made wrong conclusions.
Yeah.
Okay.
So, General Phahlane, I was referencing the arbitration award, and I would also reference the Labour Court judgment, only for the purposes that the issue that you raise on page 18 under item E relating to the panoramic system, that issue was dealt with in the arbitration. Witnesses were called. You were entitled to cross-examine those witnesses. You yourself led evidence. You then took that award on review to the Labour Court. The Labour Court also applied its mind to those issues. That is all that I'm trying to establish in response to your narrative, which appears from page 18 on the procurement, on that very same procurement contract, and which runs for a number of pages in your affidavit through to page 32, paragraph 81. That's all that I tried to do. I didn't try to argue with you. I didn't try, and I'm certainly not trying to persuade this honorable committee that you are wrong and that the arbitrator and the Labour Court was right. All I'm trying to say, General Phahlane, or trying to demonstrate rather, is that these issues have been ventilated in what all of us regard or hope to regard as independent forums, legal forums, where you have already given your side of the story, your version. So, having said that, this is your affidavit. We've agreed you're not going to be rushed. What is it now under this item E that you want to elaborate upon or to convey to the honorable committee?
You see, Chair, I refuse to accept what Council is saying. And I refuse because that's exactly the kind of narrative that has been peddled in the public domain. And I can't, in a paragraph, try and sum up the injustice that I have suffered and the narrative that has been there. Even witnesses in this, before this committee, I was listening to them. They were talking to this 24 million irregularity. I recall, I think it's honorable, but I think it was coming from some members, where they were questioning the submission to the AG to say, can you clarify us on this? That has got a lot to do with this. Facts were misrepresented before the AG, and I cannot just go over this thing. And I took note of what Honorable Malema said earlier. Why the thinking that we are going to be rushing through. And Honorable Malema, unfortunately, this is what I'm being subjected to. Look at what I'm doing in terms of that procurement, because somebody went to pay 24 million plus interest to a service provider who did not even deliver a single camera to the police. That happens in 2018, 2019, while I'm sitting at home since 2017, the 1st of June. And that is being attributed to me. That is what I'm dismissed for. To say you have allowed a service provider to take 24 million plus interest, which became 31 million, that decision gets taken in 2018, 2019. I'm giving you here even proof of who signed for that thing. And now I must, in a paragraph, sit here and say, Honorable Chair, I agree with the narrative. I'm not going to agree with it. And if we are to do justice, let's traverse this issue on paragraph E on the panoramic camera. It's not as small. The very same arbitrator that you are referring to misunderstood what is at play here. There was a contract signed. This contract was signed in 2014, 28th of July.
Yes, when you were the head of the forensics division.
Yes. So let's take members into confidence in as far as what this happened and not just narrowly go to this narrative that has been hurting to listen from people who are so uninformed.
I was trying to be of assistance because that's exactly what the arbitrator does.
No,
The
that arbitrator misunderstood.
Sorry,
Wait. Can you take a breath, both of you? I want us to do the following. The General Phahlane has accepted here before the committee that there are unsuccessful bids that he made to overturn the arbitration award. And then the last is the judgment that is awaited from the appeals court. If the matters that you are leading now, Advocate Arendse, are matters that are before the court, sitting here ourselves may not make an assessment or a review of the proceedings in a court of law. And I will want us to move to matters that pertain to our terms of reference. Unless if in those matters there is something that the witness wants to bring before this committee. To say, in terms of the 4 pillars that you have read before me, Chairperson of the committee, that you are investigating, there are the following matters that I want to bring to your attention, and I think they will help the committee to move forward. But I'm reluctant that we should confine ourselves to matters that are now before the court or take much of our time dealing with matters that are judgments or the arbitration award contained in the arbitration award or judgment of the labor court. Because both of you agree that those matters now are on appeal. So I will give you an opportunity. If there is any matter that you think you want to bring to the attention of the committee, which is not a matter before the court as we speak now, let's deal with those matters and allow the committee to move forward. Honorable Nomvalo.
Yeah, no, thank you very much, Chair. Chair, it's a clarity because I want to be on the same page with you. In fact, I was tempted to ask a question when the general raised a concern regarding some questions that are posed to him. Now, Chair, the question is, because my understanding is that to a greater extent, the senior counsel has asked questions in relation to matters deposed on the affidavit. For instance, the 360 tender or contract is deposed on the affidavit by the general. So it's not something which is outside and which is now an ambush. And my understanding is that 80% of issues raised on the affidavit are issues which are before court, the contract, because most of those issues influenced dismissal of the general. Now, the ruling that you are giving, Chair, is confusing, really. I'm confused. So how do we identify matters that he should ask and matters that he should not ask? Whereas those matters, all of them, are on the affidavit and were voluntarily put on the affidavit by the general himself. So I'm confused. I just need clarity. I'm not arguing with your ruling. I just want to be on the same page because we will ask questions after the senior counsel. And when we ask questions, we must comply with the ruling that you have made as the chairperson. So that's where my confusion is.
Okay. No, just to clarify that matter, because it is said by the witness here that the questions that the advocate is asking him are questions that emanate from matters that are now on appeal. That is what you are saying, General.
No, Chair. My discomfort was with council going to arbitration awards, wanting me to answer on an arbitration award, which is an issue that we are dealing with. So that's why I'm lost. The document that he's giving me, he's reading from, that arbitration award, even the labor court award, they gave it to me here in the morning.
Fine. The arbitration award is under appeal.
It's under appeal, but I don't have an issue in dealing with the, for example, what led to that. But I've got a problem if I must now write an exam on an arbitration award, which I don't even agree with.
You listen to what Honorable Nombalo says. The statements that are contained in your affidavit,
Yeah.
you are ready to respond to them.
Yes.
Okay. Honorable Skosana.
Thank you, Chair. Lotshani likupi, General Phahlane?
Ngiyaxolisa. I'm here. And ngiyabonga.
Lotshani likupi,
Asikhona njani.
siyathokoza.
Thokozeni.
Now, Chair, I think what the General is raising is the issue. In fact, I'm going to ask about what I heard now. He said he was given a statement this morning. It's the other one, which it was for the first time you see that statement. That bundle.
Yeah.
You only saw it this morning.
Okay. Must I answer, Chair?
I just wanted to find out, because if I heard it well, he said that he only saw this morning. Am I right?
You can respond, General.
Chair, the documents in here are not foreign to me, but these documents are not part of my submission in terms of annexures, because I have accepted that here I am not in the labor court, or I'm not in the labor appeals court. It has been dealt with there. So what council is doing, he brought these copies, like this is somewhere here, there is records of proceedings. And somewhere I said earlier that unfortunately some of these are half-baked, in that some documents that are supposed to be here, if we want to bring the whole records, bring the whole records and not selective. So I'm now being questioned to say, the arbitrator said this. I say, we have moved on from what the arbitrator said. We have accepted the laws following the arbitration process. We have accepted the laws following the labor appeal, the labor court. But we are now on waiting for a labor appeals court judgment. So why must I go into this? The issues, Chair, they are raised. It's me who raised it. Maybe, let me say, I may have instigated them. That's why they are part of my affidavit. That's why they are comprehensively addressed. So I don't understand why must I go and read an arbitrator's document that I don't necessarily agree with. If we want to have an understanding of what happened, here it is on paragraph, E. It's well captured between E. If you disagree with it, but it captures. Now I must go in, but the arbitrator said this, or an acting judge said this. I hold a view on those people. And that's why I don't agree, Chair. I'm not saying we must not. We must deal with the issue. Because, for example, the 360 camera issue, the 24 million, it's very critical. It's being brushed over. Every time an issue is being asked, even from management, they say, no, but he was dismissed. Dismissed for what? If I'm to be dismissed for 24 million, it's not me. That decision gets taken in 2018, 2019 by a sitting national commissioner who decided to settle with a service provider who laid their hands on 24 million that became 31 million. That man left the country with that money, unfortunately died. But now they say, Phahlane approved this. How do I approve something in 2019 while I'm sitting at home? The last day I was in a police office was when I left, before I left Parliament. But this is the issue. So I don't understand why we should escape it. Why must we go to a bargaining council thing, which is not talking to the real issue? The same issue is sitting before the Portfolio Committee on Police. I was listening to them, listening to material irregularity. When that issue is being raised by management, no, but the person who was responsible has been dismissed. I listened even when you were at Kgoshi Mampuru, the CFO said so, to say, no, that matter has been dealt with. Whereas the merits are being misrepresented, the facts are being misrepresented. I hope I'm clear, Chair.
It's now 13 hours. We are going to come back here at 14 hours. I want to allow yourselves time. I see you have your legal team here. The evidence leader is with his team. When we come back from lunch, you must be able to help us to move forward in a quicker pace. You had time to consult. When we started here, Matebele, you said to us that it was a marathon of consultations. And I may even need some time to rest. And that's why you requested that at least by 20 hours or 21 hours tonight, if we can allow you that time to rest. So when we come back from lunch, we want to see proof that indeed there has been consultations between you. Can we do it that way? Yeah. And I must say that it rarely happens that in our proceedings, we have this kind of altercation. We always have a smooth running of evidence presentation between the evidence leader and witnesses. So I think the committee has been very patient with yourselves. So when we come back at 14 hours, let's make sure that where you have been missing each other, you would have corrected that and help us to move forward. Thank you.
Are we going to adjourn now, Honorable Chair?
Yeah, we're breaking now. We are coming at 14 hours.
Thank you.
Thank you.